Hey everyone, and welcome back. Today we're diving into the world of third-party rights in contract law.
Which boils down to, can you benefit from a contract you didn't actually sign?
Exactly. We've got some juicy legal cases lined up.
And even a law review article to pick apart.
All so you can really get a grasp on how this all works in the real world.
The goal is for you to walk away feeling like you could teach this stuff, not like you need to call a lawyer every time a contract pops up.
I love that. So picture this. You're ordering pizza.
Right? Always a good start.
You order it for a friend. It shows up late. It's cold. They're starving. Can your friend sue the pizza place, even though you were the one who actually ordered it?
Okay, so right there, you've hit on a really key concept. Third-party beneficiary. It's not enough to just benefit from a contract someone else made. The real question is, was the contract intended to benefit that third party?
So in the pizza case, the pizza guy probably doesn't even know my friend exists, so unlikely.
Exactly. But let's say you and we enter into a contract, and part of that contract is that I'm going to pay off a debt you owe to a friend.
My friend's not involved in making this deal, but they're definitely going to benefit from it.
Precisely. And this idea that a third party can have enforceable rights under a contract they didn't sign, it's been around for a while.
We're talking legally binding stuff here.
Oh, yeah. In fact, there's a landmark case, Lawrence v. Fox, that really solidified this concept in common law.
I've heard of Lawrence v. Fox. So essentially, this case said, even if you weren't sitting at the table when the contract was made, if it was designed to benefit you, you have a right to enforce it.
That's the gist.
Okay, so that's the legal theory, but let's bring it back down to earth for a second, because these cases can get messy.
They can get very real very fast.
Our sources mention a case, Seaver v. Ransom, talk about an emotional roller coaster.
This one involved a deathbed promise, a house, and a niece who got cheated out of her inheritance.
Wait, seriously?
Yeah, so this woman, on her deathbed, promises her husband that she'll leave their house to his niece in her will, but then she doesn't follow through. And the niece is left with nothing. So she sues, and the courts actually side with her. They recognize her as the intended beneficiary of that promise, even though she wasn't a party to the original agreement between her aunt and uncle.
That's wild. See, that's why this is so important. Because we often think of contracts as these dry, legal documents.
Just business, black and white.
But Seaver v. Ransom, that just shows you how personal and emotionally charged these situations can be.
And it underscores the need to be crystal clear about your intentions when you're entering into a contract, especially if it might impact someone else down the line.
Absolutely. So we've got this concept of a third-party beneficiary, someone who benefits from a contract they didn't sign.
But it's not a free-for-all. Not all third parties are created equal in the eyes of the law, right?
So there are different types. Lay it on me.
There are actually three main categories we need to unpack. Done beneficiary, creditor beneficiary, and incidental beneficiary.
Three types of beneficiaries. That's where I start to get lost. Can you give me a real-world example of each, just so I'm clear on the difference?
Sure. So imagine you're the beneficiary of a life insurance policy. Someone else takes out the policy, pays the premiums, but when they pass away, you get the payout.
That makes me what was it?
Yeah.
A done beneficiary.
You got it. A done beneficiary is essentially receiving a gift. The contract, in this case, the life insurance policy, was intended to directly benefit them.
Okay, that makes sense. What about a situation where a contract is designed to settle a debt? Like, let's say I'm a freelance designer, and a client hires me to create a logo for their new business.
Okay, I'm with you.
But they're short on cash, so as part of our agreement, they promise to also finish building that website I've been bugging them to do for months.
Interesting. So the website design is essentially payment for the logo.
Exactly.
In that scenario, you become a creditor beneficiary. The client's promise to build your website, which is part of a separate agreement, is intended to satisfy their debt to you.
Got it. So done beneficiary is like a gift. Creditor beneficiary is tied to settling a debt. What about those situations where you benefit kind of indirectly from a contract, like as a side effect?
Ah, you're talking about incidental beneficiaries. This is where things get a little trickier, and it's often a point of contention in legal disputes.
Give me an example.
Okay, imagine a new development project in your neighborhood leads to increased property values for everyone in the area.
Nice.
Yeah.
Sounds like a win-win for the homeowners.
Yeah. Sure, on the surface, but does that mean every homeowner gets to sue the developer, claiming they were a third-party beneficiary of the contract for that development?
I mean, I'd take a free property value boost, but I'm guessing it's not that simple.
Not quite. This is a classic example of an incidental beneficiary. While they might experience a positive side effect, it wasn't the intended outcome of the original contract between the developer and, say, the city or whoever they made the agreement with.
So it's like that old saying, a rising tide lifts all boats.
Exactly. A rising tide lifts all boats, but that doesn't mean every boat owner gets to sue the tide. The key, again, is intent. Was the contract designed to directly benefit those homeowners? Probably not.
Okay, so intent is king. But how do courts actually figure out what the parties intended? Especially when we're talking about someone who wasn't even involved in the original agreement. That seems incredibly difficult.
It can be, and that's what we're going to dig into next.
It's like being a fly on the wall during those contract negotiations.
Well, not quite, but you've got the right idea.
You're looking for clues, trying to piece together what those parties were really thinking.
Exactly. And one of the first places we look, of course, is the language of the contract itself.
Makes sense. Always start with the source, right?
Right. Our sources mention a case, Evening News Association v. Peterson, which centered on a news anchorman's contract. And the question arose, could that contract be transferred if the TV station was sold?
Oh, interesting. So, let's say I have a cushy contract with one station, and then a bigger network buys them out. Can they just say, too bad, your contract is void now?
That's essentially the issue in this case. The anchorman argued that his contract was tied to the specific station he signed with, and the language of the contract itself didn't explicitly address assignment, whether the rights and obligations could be transferred to another party.
It was silent on that point.
Exactly. So the court had to really dive into the weeds, looking at things like industry norms, the anchorman's unique role at the station.
So they were trying to figure out if there was anything implied by the nature of the agreement, even if it wasn't spelled out word for word.
Precisely. And they ultimately determined that, yes, the contract was assignable in this case.
Wow, so even if a contract doesn't directly address something, that doesn't mean you can just assume you're in the clear. The courts might interpret the original intent in a way you weren't expecting.
Exactly. And that brings up another common pitfall, which is this whole issue of modifications. Let's say a contract is initially assigned to you, but then the original parties, they decide to change the terms.
Hold on. They can do that. Once a contract is signed, sealed, delivered, they can just go back and tinker with it.
Well, it depends. Contracts are often complex, with lots of moving parts, and sometimes those parts need to be adjusted along the way.
But what if those adjustments affect the third-party beneficiary? Do they have any say in the matter?
That's a great question. And it can be a recipe for conflict. We've got a great example of this in our sources, the case of Rosenberger v. Sun Inc., which revolved around, of all things, a Dairy Queen franchise.
Dairy Queen, always a good time. What happened?
So the original owner of this Dairy Queen, he decides to sell the franchise, and he assigns the existing contract to the new owner. Sounds simple enough, right?
Sure.
But here's the catch. After the assignment, they decide to change the location of the Dairy Queen.
Wait, they moved the whole Dairy Queen after the contract was assigned?
Yep. And this change of location, it ended up having a big impact on how much money the franchise made.
Because location is everything, right? Especially for a business like that.
Exactly. So the court had to grapple with this question. Even though the contract was assigned, did those modifications to the original agreement impact who was ultimately liable? Could the original owner still be on the hook even though he'd sold the business?
So what did they decide?
In this case, they determined that the original owner, despite assigning the contract, could still be held partly responsible because of the significant changes that happened after the assignment. It's like you're handing off a baton in a relay race. Just because you've passed it on doesn't mean you're completely off the hook. If the next runner drops the baton, you might still be held accountable.
That's a perfect analogy, and a good reminder that even if you assign a contract, it doesn't mean you can just wipe your hands clean and forget about it.
Exactly. You might find yourself as the proverbial backup dancer, liable if the primary assignee doesn't uphold their end of the bargain. This gets into the concept of surety relationships, which are important to understand but a bit of a rabbit hole.
So we've talked about the importance of intent, how courts try to decipher what the original parties were thinking. We've also seen how things can get messy when contracts are silent on key points, like assignment. And now we're seeing how modifications made after a contract is signed can have ripple effects, even impacting who's ultimately liable. But what about those situations where a contract just can't be passed on, even if it doesn't explicitly say so?
Right, because some things are just too personal or too specialized to just hand off to someone else. Like, I can't say, oh, I hired Michelangelo to paint my portrait, but, if he's busy, feel free to send over one of his assistants. I'm sure they've picked up a few things.
Exactly. And there's actually a fascinating case that illustrates this point perfectly. It's called Crane Ice Cream v. Terminal Freezing. This ice cream company, they had a contract with a local supplier for their ice needs. Okay, so far so good. Ice cream needs ice, makes sense.
Right, but then the ice cream company, they get bought out by a much larger company, a bigger fish in the sea. And this larger company, they already have their own ice suppliers, national contracts, the whole 9 yards.
So they want to get out of the original agreement.
Exactly. They try to assign the ice contract to this bigger supplier, but the original ice company, they say, hold on, we had a deal. You can't just back out now.
And they took him to court.
Over ice.
They did. And the court actually sided with the little guy in this case. They said that this wasn't just about delivering a generic product. There were personal relationships involved, a reliance on the original supplier's understanding of the ice cream company's specific needs. Interesting. So even though the contract itself didn't explicitly prohibit assignment, the court recognized that there was more to it than met the eye. It was about more than just fulfilling an order.
Exactly. It was about that personal touch, that element of trust and understanding that had been built up between the original parties.
That's a great point. It's a reminder that contracts aren't just these cold, impersonal documents. There are often real people behind them, real relationships, and those factors can have a big impact on how a contract is interpreted and enforced.
Absolutely. And it's something that anyone entering into a contract, especially one with long-term implications, should keep in mind.
So as we wrap up this deep dive into third-party rights, what are the key takeaways, the need-to-knows for our listeners out there?
Well, first and foremost, awareness is key. Don't just assume you're covered by a contract just because it might benefit you in some way. Read the fine print, folks.
Seriously, knowledge is power.
Look for those clauses about assignment, about consent, about what happens if the original terms of the agreement change. And if anything is unclear, don't hesitate to ask questions.
Right, because once those signatures are dry, it can be a lot harder to undo something you didn't fully understand in the first place.
Precisely. And remember, even if you weren't physically present when the contract was signed, if you can demonstrate that you were an intended beneficiary, not just someone incidentally benefiting from the situation, well, you might actually have a leg to stand on if things go south.
It all comes back to intent and proving that the original parties had your interests in mind, even indirectly.
Exactly. And finally, don't underestimate the power of those personal factors, the nuances of the relationships involved. Those can make all the difference, as we saw in the Crane ice cream case.
Contracts are fascinating because they're about so much more than just the words on the page. They reflect the complexities of our agreements, our intentions, and sometimes even our mistakes.
Couldn't have said it better myself.
Well, on that note, we've reached the end of our deep dive into the world of third-party rights.
It's been a pleasure exploring these cases with you.
Likewise. And for our listeners, we hope you've gained some valuable insights today. Remember, knowledge is power when it comes to contracts. Until next time, stay curious and stay informed.